I have for you 4 new Sarah Boone letters. All of them come in the form of motions. These have already been seen in court for her latest appearance. If you haven't watched that, I will be bringing up some context as we go for what happened in that court appearance since I watched it. Motion for defendant's immediate address correction. Comes now Sarah Boone, pro se, indigent defendant, respectfully requests from the court to change, update, correct the defendant's delivery mailing address immediately. The defendant is unclear how the court had the correct address prior to the forfeiture of her counsel by the court and forced to become pro se and now does not. This incorrect address was not provided to the court by the defendant nor requested ever to be changed. All correspondence to the defendant by the court is being delayed in receipt of due to this error, which deters the defendant's real-time response, prior notice, and preparation of any requirement contained therein. The defendant is requesting the court please forward the correct address to all parties affiliated in her criminal case, including all portals, correspondence tags, and all lists the defendants may be attached to by the court. Also provide all necessary documents for official record of address change to be filed accordingly by and in the court. By this motion, the defendant is expecting no further hindrances, difficulties, deterrences in the court. Fair and proper correspondence be delivered to the defendant the following correct address, and this is her address to the jail. Please be advised also the defendant mailed by USPS this information by formal letter to the court on August 1st, 2024 to emphasize the importance of this immediate correction to be made in the court's behalf and from the court's error. Therefore, Sarah Boone, pro se indigent defendant, respectfully requests to his honorable in conclusion to correct immediately the defendant's delivery mailing address and forward to all parties affiliated in her care, and there's the oath. So this is the first letter. This is the August 1st letter she mentions. Judge Kranick, I am unclear how the court had my correct address prior to you forfeiting my right to counsel, 6th constitutional amendment, and forcing me to become pro se and now does not. All my pertinent responses being delayed in my receipt of due to the court's errors of sending the wrong address now. This deters my fair, proper notice and any preparation required. Please correct immediately. Also forward to whomever change in portals, correct all correspondence tags or lists I am attached to, including and by this notice, I'm expecting no further hindrances, difficulties in this matter from the court's immediate attention, understanding of the importance to receive all correspondence timely and appropriately. And then we have the what I would call the circus font for exactly, because it really looks like that ad for the attorney that may look like a circus ad. And there's her address. No more deterrence, please. The court is appreciated. Thank you. So she's just wanting to have her jail address corrected. I'm assuming they're sending it to the wrong location. It's taking a little longer to get to her. By the way, it was brought up that it will be corrected, so that's not an issue now. Motion for defendant's reasonable freedom and movement by allowing her to be unshackled, unhandcuffed to function equally and comfortably while utilizing the courtroom. Come now, Sarah Boone, pro se, indigent. I am never going to be able to pronounce that word. Defendant respectfully requests from the court to be unshackled, unhandcuffed, and allowed to reasonable freedom and movement to function accordingly, equal and comfortably while utilizing the courtroom. The defendant must be able to write, reach, turn pages, pick up objects, open documents, pass information, utilize laptop, all normal movement of the defendant's hands as a wholly, freely, properly successful, accomplish any task needed for. I mean, this makes sense, right? It makes sense that if she's supposed to be representing herself, she's able to take notes and do things in court. To me, this makes sense. But they did say in court that there wasn't really an issue. It doesn't sound like it from the court side or the prosecution side, but the people that are responsible for her and her safety, the sheriff's office, I think in this case, has to, give the approval for that. Probably have some extra guards. Prior to entry to the courtroom, the defendant is thoroughly inspected, searches under direct surveillance of the judge, all judicial assistants, news cameras and their operators, photographs, general public witnesses of the court, as well as vigilant armed deputies, also in attendance, greatly diminishing all possible risk of flight or harm by the defendant while unshackled and handcuffed. The defendant is simply requesting equal, comfortable, functional movement to achieve advancement in her forfeited right to counsel by the court, which would greatly enhance the productivity and progress for the defendant and the compilation of her defense in her criminal case in preparation for trial. The court's overall perspective and correct understanding of this performance obstacle for the defendant is also requested respectfully, seeing her good faith, determined efforts to thrive and achieve in her criminal case rightfully, properly, fairly. Therefore, Sarah Boone, pro se, indigent defendant, respectfully requests to his honorable court, in conclusion, to be unshackled, unhandcuffed, and allowed reasonable freedom and movement to function equally, accordingly, and comfortably in the courtroom. I think she'll get this. I don't think that's a problem. So here's where things get kind of interesting. Motion for defendant to lawfully receive, review, utilize the original hard copy discovery, 2 boxes A-B, submitted to the court by former attorneys June 28, 2024 for preparation for trial in her criminal case. She is wanting the hard physical copies, and this is going to be an issue. This is something that was brought up. She has told the judge previously she has no privacy, nowhere to store things, which means her being able to store these hard copies of her discovery is impossible. She's claiming now she might have a location, but hard copies, again, are just hard in general for the jail to cover. It sounds like the jail is going to be the deciding factor about whether she gets these hard copies, because Sarah Boone does have access to digital of all of this. And I do not know if it's brought up in this. I have not read through this particular one yet. But it was also brought up that she wants access to the physical evidence and to inspect them. She wanted privacy to do that. That's not how that works. But she wanted privacy to inspect like the physical evidence, things like the suitcase, I assume. And to do that, that has to be done in front of a lot of eyes for obvious reasons. She didn't want the media to be there. But it does sound like the judge is possibly okay with limiting the media access to that portion, but he needs to see if it's even legal to do so due to the laws in Florida. The prosecution suggested that anything that's really sensitive, they would be able to send probably digitally, like crime scene photos and stuff, so that wouldn't be an issue with the media there. She also really wants access to her phone, and she kept being told that, hey, we give you a full digital backup of the phone. You can have your own digital backup. All your contacts are there. But she kept repeating very obviously she wanted physical access to her phone. And it doesn't sound like they're going to give that to her. I'm assuming she wanted to call people from her phone because she only has access right now to a phone in the jail. I don't think she's going to get that. Let's dive in. Comes now Sarah Boone, pro se indigent defendant, respectfully requesting the court to lawfully receive, review, utilize the original hard copy discovery, 2 boxes A, B, submitted to the court by the former attorney. Attorneys on June 20th, 2024 for preparation of trial in her criminal case. Lawful support and valid reasons for this request may be the defendant include discovery definition. This is just a definition. Exploration or examination, finding something out by search or observation. Smart Com tablet dictionary. So she's, again, quoting dictionary stuff. Again, remember, she has all of this in a digital format. All of this is given to her now. She should have it on a USB drive that is usable with the computer. This was talked about in court. And there's another dictionary. I'm not going to read her dictionary definitions. I'm sorry. Filed and at least when she doesn't add her own little tidbits in there. Filed and posted on the clerk of the court's website by the judge on July 9, 2024 at 9:31 a.m. The evidence contract sheet states this is just a list of her discovery A and B boxes. Here's some more discovery rules. You can read that if you'd like. You can slow down the video or pause it. But she's not making anything special here, right? There we go. So I guess there's a little bit here. So we'll go to the government is obliged under Brady to disclose information, sole possession that is a material to the issue. And places heavy reliance on the cases that held information is material if there is reasonable probability that had discovered. Okay, so that's again a quote. Any document request made. Okay, it's a quote. By the court only providing digital USB. Here we go. Finally, discovery to be viewed solely on the laptop produced by the OCCD and restricted to select times during the day only. Motion for extended times in process. So she's wanting more time with her laptop, which doesn't seem possible. Without the necessary hard copies, the defendant is unable to review, research, investigate, build her defense at any time. Numerous hours are ineffectual and wasted by not having access to the laptop and by not having the original hard copies available to use physically during the laptop's closed hours. So this is something she mentioned. She wants to have physical access so she can keep looking at them like in her cell outside of the hours she can't use the laptop. But again, there's an issue with getting her these actual documents, and the judge really can't force them to give them to her as far as I'm aware. Write notes, remarks, interpretations, explanations, make recordings of any kind. Transport to meetings in any location, including the courthouse. Make copies for distribution or any necessary presentations in court. If one form of the defendant's discovery is unavailable, the other should be available without interruption for unrestricted full access equally at all times, be able to lawfully prepare for trial. Both are available to be provided by the court. Do the court's error of not communicating with the defendant foremost to avoid pertinent circumstances in the jail prior to the implementation of the order on June 28, 2024, after the defendant's July 9, 2024 letter questioning the location of her promised hard copy discovery, 2 boxes A-B, as a direct result of her extended waiting period for delivery by the court to expeditiously review, research, organize all contents, and attempt to prepare all pretrial motions as ordered by July 22nd, 2024. The defendant is now forced in this abrupt manner to only receive and be restricted by the court USB copies of her discovery. It is an obstruction of justice to withhold the defendant's original hard copy discovery that has been compiled by the ongoing 5 years to properly, fairly, physically construct her rightfully defense of all available times necessary to her own the sole independent decision of the court, as the defendant did not ask for or suggest this USB-only option. I don't think she asked for a USB-only option, but I think it is the only option. Was not included in any decision-making, collaboration, or equal agreement for the USB-only format to be received. Was never advised by the court prior to implementation or receiving USB copies. The defendant was excluded and also avoided in this incredibly restricted decision. Time, consideration, and inclusion could and should have been made by the court's behalf to frequently avoid present disadvantaged circumstances, and the defendant will not be deprived of her due process and equal opportunities to correctly, fairly represent herself and succeed futurely. I mean, how do I want to put this? This is her fault because she's scared away 8 lawyers, 8 attorneys. It's her fault. She's in jail. There are limits when you're in jail. They're giving her access to everything they can. The judge is letting her have access as much time as the jail can allow her. I don't know what she really wants them to do, because she is in jail. Like that's something I think she forgets sometimes. Wherefore, Sarah Boone, pro se, indigent defendant, respectfully requests for his honorable court, in conclusion, to lawfully receive, review, utilize the original hard copy discovery 2 boxes AB submitted to the court by the former attorneys on June 28, 2024, for preparation of that in her correspondence. I believe they told her that if she can get the jail to agree, she can have it. Like, it's not an issue of the judge being against it. It's an issue that she can't have it. By receiving the original hard copy discovery, 2 boxes AB, in addition to the USB digital copies, the defendant is capable of viewing all discovery information available in continuous preparation of her trial, enhancing her ability to thrive lawfully and are forced by the court position of pro se representation of self. There was also some stuff brought up in court where she wanted to have standby counsel, and she seemed to not understand what that meant. She seemed to think it was more like a lawyer who was her secretary, who will do what she asks, which is what she was really kind of wanting from all the previous lawyers, right? And they had to correct her. That's not what that is, and she doesn't have a constitutional right to one. Anyway, it's for people who choose to be pro se, which she didn't. Which, there's definitely going to be an appeal for that, right? There's going to be an appeal based on the fact she's representing herself, but it sounds like the judge is open to, like, whatever needs to be done to, like, get her this stuff, but she's an inmate. There are restrictions, and those have to be understood.